All right, welcome everyone. My name is Greg Brandis. I'm the Dean of St. Francis School of Law, and it's my great pleasure to welcome you to our session looking ahead at the 2020-2021 United States Supreme Court term, which began today with arguments in one of the cases that we'll try and talk about at the very end of our session tonight if there's time. It's always a very exciting time of the year for lawyers, those who track, of course, the important decisions that the court makes. And it's also, of course, a very exciting and important time for the jurists and everyone in the government who pays close attention to all these cases because they very directly often affect exactly what government actors can do as well. This year is especially, shall we say, exciting because of events that have recently unfolded with the very sad passing of Justice Ruth Bader Ginsburg and the likelihood of a Senate confirmation hearing on a replacement justice in the very near term as the court has begun its work. I will say that traditionally, brand new justices do not participate in cases for which they have not heard the arguments. And so there will be some adjusting to do as a new justice joins the court during the term. But this is not unprecedented. This kind of thing has happened before, and everyone sort of understands what to do about it. What may be, of course, unprecedented is the shift in the court or the change in the court, depending on what happens with confirmation and the nature of the justice who is appointed. We are sometimes very surprised at what justices do after they get on that most supreme of benches, however. So we'll bear that in mind as we think about the cases tonight as well. With me tonight is Dr. Roger Cusick, who is professor at St. Francis School of Law, teaches constitutional law. Welcome, Dr. Cusick.
Good evening. Good evening. It's a pleasure to be here.
Thanks for being with us. And we are going to begin without further ado, because we have a lot of cases on our plate tonight. Just one administrative announcement, and that is we are pleased to take your questions at any time. You can use the Q&A function within your system to post them. I will take questions generally at the end of the session, however, but don't take that to mean you should wait. Go ahead and post them as they come to you, and we'll reserve a few minutes at the end of our session to answer some of those questions that may arise. And remember, this is a look ahead, and we will cover quite a few cases tonight. So, of necessity, we will cover them fairly briefly, and there is much more to say about many of these cases. But we want to give you sort of an overview snapshot of what's ahead for this new court and new term. So I'm going to start a screen share with our slides for tonight. And then Dr. Cusick, I'm going to pass this over to you pretty rapidly to begin with our first case, which is the Torres versus Madrid case.
Okay, thanks, Greg. Thanks for inviting me, and thank you to everyone for being here. The Torres case, I picked that to start because it had some interesting facts and has some long-term consequences. Roxanne Torres is the plaintiff, and Madrid and Williamson are the defendants. It arises out of a police surveillance in the middle of the night in Albuquerque, New Mexico. They were waiting for a big drug deal to come down. The police were armed and wearing SWAT outfits, although they were identified by police. It was dark, and they had helmets and the usual gear. Roxanne Torres comes driving along and backs her vehicle into a parking space right within this surveillance, unbeknownst to her. Some of the police approached the vehicle, and according to her testimony, she was wasted on meth. She overreacted, panicked. Her companion jumped out the car window, and she jumped on the gas and sped right at the police. Two of the police pulled their weapons and fired at her 2 bullets. She was hit twice. Despite that, she gave it gas and sped away, got away, and drove 75 miles across New Mexico, where she finally stopped because she had another accident. And while the accident was being cleared She jumped into an idling car, stole it, and drove away, eventually to a hospital. She's helicoptered back to Albuquerque, and they identify her, go through the prosecution. At any rate, all of that relates to the question of whether or not this was an unsuccessful attempt to detain her and what type of physical force was involved. Because she brings an action under the Fourth Amendment for a violation of her civil rights based upon excessive force. Now, the courts, both the district court and the 10th Circuit, I think it's the 10th Circuit, found against her, dismissed the case based upon a summary judgment. And the basis of the dismissal was that the Fourth Amendment requires a search or a seizure, and a seizure must occur either by force or by a show of authority and somehow demonstrate a loss of freedom or an interruption with her movement. And Roxanne Torres did not stop or in any way recognize the police even. So when she testified, she said, as I mentioned, she was gone on meth, and she just simply thought they were about to carjack her vehicle. So when she sped away, she didn't answer to any response, any type of command or instruction from the police. The district court dismissed it for summary judgment, uh, which began with the motion based upon the officer's implied immunity. But the basis of the dismissal was really that there was no seizure justifying a claim for the Fourth Amendment violation. And the question in the district court and the 10th Circuit was the same. Where is the seizure? And those courts made a finding that the use of force by itself is not a seizure. The appellant, Torres, now seeks the Supreme Court to define the use of force as a basis or demonstration of seizure. Now, they're both looking at past cases, one of which is the Brayland case, which defined a seizure as any interference in the freedom of movement of a suspect, and that any interference could be of any length of time. So, however brief, there could be a justification for a seizure and therefore a basis for the claim. At any rate, the appellant and her supporting amicus briefs want a demonstration or a statement that any amount of contact is force, and any amount of force in any form is a seizure. And that would open up the Fourth Amendment claims substantially, so that events like tasers, chokeholds, any type of lethal force, and obviously blunt force, all would constitute seizures when they do not. There's a current split with the circuit courts on this question, and we think, or at least I think, that the Supreme Court took the case so they can answer the question and further define what a seizure is under the Fourth Amendment. Okay, Greg. Parita versus Barr is a very interesting case involving the question whether a criminal conviction bars a non-citizen from applying for relief from removal from the record of conviction. Now, here is the problem here. It begins with Mr. Parita, who was 25 years a non-citizen resident or illegal immigrant in this country, paying taxes, working with a family of 3 children, married. When he attempted to gain a different job, he submitted a bogus, false Social Security card. And that Social Security card usage resulted in the charge of criminal impersonation in Nebraska. And now there's 5 or 6 elements of criminal impersonation in the crime. The point is that he pled guilty to it generally, and then he was called upon by the Immigration Service for a removal hearing. Now, removal or deportation, as it's commonly called, he was a candidate for it, and with 2 possible exemptions. One is if he was seeking asylum, which he's not, and the other one is a type of good faith defense in which circumstances, including his 25 years as living here, his family, the sole bread winner, etc., would justify an exemption from removal. The only condition of that exemption is that he not have any felonies on his record. The felonies are judged according to a standard, but the federal government has set up to compare a crime involving moral turpitude with the charges of the underlying crime. So Parita's plea of guilty to criminal impersonation has to be matched up against the definition of a crime involving moral turpitude, or CIMT, to evaluate it to see whether or not he qualifies for an exemption. He has the burden of proof in doing so. It's what we call a divisible statute, which means some portions of the statute are CIMT, others are not. Those that are not are eliminated immediately, and the ones that are looked at are the ones that have potential CIMT, or crimes involving moral turpitude. If it is his burden to decide and prove that his actions were not the CIMTs or were the non-CIMTs, he goes to his hearing, and the immigration judge finds that he failed to achieve his level of proof, and he was ordered removed or deported. He took it on appeal. It went up to the 10th Circuit also, and each time he's lost, because the rule is that although the Nebraska statute was not shown to be a CIMT, Parita failed in his burden of proving that it was not a CIMT, and there's a longstanding rule that the burden of proof is on the non-citizen. So the question here is that, first, should he be held to that standard given his background? And is that imposing the burden of proof on him an unfair situation given the presumption in the statute? There is a presumption in the law that the immigration judge will impose or go by the least criminal element of the Nebraska statute in this instance. And the immigration judge claims in his decision that he did so, but he still found that Parita failed in his burden of proof, and consequently, Parita has lost at each level going up to the Supreme Court. So one is this presumption, whether or not the court will go along with the interpretation of it by every court below it, or 2, whether or not there's a fairness issue imposing this burden on the alien to come up with this type of documentation to explain the statute as not a CIMT, whether he can really do that. And the government makes an extensive argument that Congress's intention was to impose the burden on the alien. He can go back to the court and get his transcript. He can get the court file from Nebraska. And in this instance, Parita did nothing, did none of these. So the implication is he failed in his burden of proof, and he would like to obviously be able to stay in this country given his background of 25 years. So the court, I suspect the court took the question because it is the immigration policy, and the volume of deportations has increased so substantially. Thank you. Greg, you
Let's unmute first. Sounds like it's a decision that would have wide consequences, I guess, even if the case didn't involve a CIMT. This kind of core question of who has the burden in these immigration removal cases.
well, it's a very heavy burden. And what happens is that in this instance, Parita went into Nebraska court. He pled guilty, paid no fine, no penalty whatsoever, and walked out, putting that behind him. And then when he got, little did he realize the consequences of that plea to this low-level felony with no penalty would be that would result in his deportation.
Yeah, yeah. So we need better clarity on questions like that for sure. Well, thank you. Wonderful. Well, we're gonna turn from that to a question that affects pretty much everybody in some fashion or another, or at least a couple of cases that arguably do. The first of these cases involves the Android operating system, which I suspect a fair number of those folks who are with us own a device that uses the Android operating system. The case is Google versus Oracle. And the essential facts are that when putting together Android, Google used some things from a programming language called Java. They used some organizational things, some functions, that sort of thing. And they built their own language for programming it, but they borrowed a fair amount of those concepts from the Java language, which is owned by Oracle. So the question that this case has been going on for almost 10 years, dozens of amici curiae have weighed in on this question. And the two questions certified for this certiorari, whether copyright protection extends to a software interface, which is essentially the part of Java that Google used, and whether, as the jury found, using software interface in the context of new programs constitutes fair use. I want to give you just a little bit of the procedural background on this because it is a little bit complicated. It's been going on for a long time. The original district court found that the APIs are not appropriate copyrightable subject matter. They don't fit within the statutory definition. Court of Appeals for the Federal Circuit reversed that, saying that they do, but there might be a fair use argument. So then we go back to the district court, and the district court finds that it is fair use. And then we go back to the Federal Circuit, and they find that that's not fair use. It's not within the fair use definition. So we now have it in front of the Supreme Court essentially to decide both the questions of copyrightable subject matter and the questions of fair use. This argument has now been broken up because the Supreme Court actually invited the Solicitor General to weigh in on this question as an important question of federal law. And so now there will be multi-party oral arguments to be held in the case coming up actually pretty soon on October 7. That's, 2 days from now. Just a little bit of the argumentation that's going on in the case between the parties. Google essentially argues that the settled standard of review for these things has been satisfied, that a reasonable jury had a legally sufficient basis, and therefore the courts above should not be reviewing the jury decision on this de novo, which is essentially what the Federal Circuit did, or at least what Google argues it did. Oracle, of course, argues the opposite, that de novo is appropriate in this circumstance. Why? Because of the importance of the question to things like the progress of science, the arts, free expression, etc., wrapping itself in the flag. And then, of course, arguing that it's not fair use because they are superseding the platform that Oracle otherwise would have been able to sell them. So the important thing about this case to millions of us, of course, is if it does result in a finding that it is copyrightable subject matter and there is no fair use exception, then arguably Google will be responsible for likely billions of dollars of royalties to Oracle for use of its software interface. And that, of course, will impact the access to the Android operating system and the expense that goes along with it for us as consumers. So it's an interesting case, kind of detached from us individually, but very important because it touches something that we all, or so many of us actually use every day. And last term, we had challenges to the way Apple operates its operating system. So the Supreme Court's been dealing with cell phones quite a bit, or mobile devices quite a bit in the recent past. Next to that, we can also put in another case that involves the device that almost all of us have in our hands, and that is this Facebook versus Duguid case. This is a case about text messaging in which Facebook sent a terrific number of text messages over 10 months to the plaintiff, warning the plaintiff that someone was trying to access his Facebook account, which the plaintiff did not have. So this plaintiff was upset with this and found it a violation of the Telephone Consumer Protection Act of 1991, violations of which, I should add, carry a $1,500 per violation potential fine. And of course, there were dozens of these messages, and there are literally thousands upon thousands of these potential plaintiffs. The argument was that the act prohibited the use of automated dialing devices. ATDS is the shorthand for it. We'll call it auto dialers. On a very technical basis, Facebook claims that the device they used was not, in fact, an auto dialer within the meaning of the statute. And that's what the court has to decide. Does that definition encompass any device that can store and automatically dial telephone numbers, even if that device does not use a random or sequential number generator, as is mentioned in the statute? So it's a statutory interpretation of federal statute for consumer protection purposes, and a pretty kind of a classic case. Of course, it has implications for all of us who receive an increasing, I think, fair to say, number of these junk texts, or also other kinds of phone calls that are generated to our mobile devices. So the federal district court procedurally didn't pay any attention to this claim, whereas the Ninth Circuit decided it did. The Ninth Circuit has historically had a broader definition under the Act than most of the other circuits have had. And they ruled that it only has to have the capacity to store numbers to be called and dial such numbers automatically to qualify under the Act. Facebook petitioned the Supreme Court for review. Their arguments primarily boil down to just the mass or the size of these kinds of complaints that could be brought at $1,500 a piece against an entity like Facebook, where, according to Facebook's version, all they were doing was trying to protect the poor user from a security breach, or potential security breach. There is a split among the federal circuits on the issue. Quite a few other circuits have taken a much more confined view of the definition, and that requires it to apply really only to devices that essentially dial randomly. And the Supreme Court took it to settle the disagreement among the various circuits. So here again is a little bit of the argumentation from the parties in the case. Facebook argues that you can't decouple the definition of storing and dialing from the definition of random numbers and sort of a randomization. The Facebook argument is that specialized machinery was designed in the 90s and before that used the existing telephone network of the time to make these calls, and that is what this statute was designed to address, not modern systems that, of course, they store numbers as well as randomly generate. They can do both of those things. And modern systems, of course, entirely computer-based. Facebook characterizes auto dialing as a small universe of rapidly obsolescing robocalling machines. This is quoted in the respondent's brief a little sardonically, because of course we all experience dozens of these calls a week. So it's hard to imagine that Facebook can genuinely argue that this is a vanishing problem, which it seems to be doing with its very, very narrow interpretation of the statute. The respondent essentially argues it's pretty clear that this is intended to apply to prevent this sort of thing, unwarranted and unapproved sort of contact through these means to the individual's device. Once again, a primary reason for the case being in the court is settling the disagreement among the circuits. So back to you, Dr. Cusick.
Thanks, Greg. The Fulton versus City of Philadelphia case involves about a dozen plaintiffs, individual plaintiffs, but the real party in interest is Catholic Social Services against the City of Philadelphia, and it arises out of a March of 2018 article published by the Philadelphia Inquirer about foster child placement services in the city of Philadelphia. There are, I think, 10 or 11 services in the city of Philadelphia that provide these placement services for children. The city routinely contacts the service steps up, provides families and matches families to the children. Now, in that article, they mentioned that there were two of the services, namely Catholic Social Services and another entity, Bethany Social Services, Christian Services, Bethany Christian Services, as the two only faith-based services, and both of whom had restrictions on who would be qualified as foster parents in their placement. The Catholic Social Services places children only in married couples or single person households. It does not place children in couples that are living together, so cohabiting adults. And as a result of that, or as a part of that definition, same-sex marriage in the eyes of Catholic Social Service, CSS, that is not a marriage, but they are cohabiting adults because of Catholic doctrine denying the marriage, the gay marriages. The article in the Philadelphia Inquirer revealed this information or talked about this information, and the Catholic Social Services, which had been in existence since 1918, placing children, and the Catholic Church before it since 1797, placing children, was put in a situation where the city froze the foster children out of the CSS and Bethany Christian Services, subject to a conference. They met with Bethany, and Bethany agreed to change its rules and do placement to gay couples. The Catholic Social Services met and resisted the suggestion that they do so. The commissioner also in the process said, maybe you should adopt the philosophy of Pope Francis and skip the Catholic ideology. Pope Francis would allow this, and you should allow this. They took umbrage with that, and they refused to do it. These contracts were a yearly or 2-year contract, and the CSS contract, they froze them as it was, and then they had a few weeks left on the term. In the few weeks, the CSS sued the city of Philadelphia, claiming a violation of their First Amendment rights, the free exercise of religion. because they claimed that the city was attempting to interfere or was interfering with their exercise of Catholic ideology and faith. And the time ran out on the contract, and that expired. They renewed the lawsuit, or they restated the lawsuit based upon, you know, the refusal of the city to renew the contract. So we have this nebulous area about whether there was a contract and it expired and whatnot. At any rate, they have a 3-day hearing, and I go through all these facts because they're germane on this appeal now. They have a 3-day hearing, and the hearing in federal court uh, refuses to grant the relief to CSS, meaning an injunction and an order restoring their status with the city. They go up to the Third Circuit. Third Circuit affirms, and they're now at the doors of the Supreme Court. The basic situation is this: that the city claims it has an obligation under its, under its charter and under current philosophy not to discriminate against anyone by reason of sexual orientation or because they're gay or they're married, uh, they have a gay marriage. And the CSS claims that this is a trumped up device used because they're targeting the Catholic ideology in the city of Philadelphia. And the reason why I think that CSS is taking this approach is because they have to get around the Smith case. To Smith, the Unemployment Division of Oregon versus Smith is an important case since 1990 because it requires or allows for a neutral, generally applicable law to be used in this situation dealing with the First Amendment rights. If you think back on Smith, Smith involved two counselors in the unemployment division in the city or the state who were drug counselors helping the unemployed. It turns out they were Native Americans who used peyote in their religious ceremonies and religious and cultural ceremonies in their off duty hours. And the state got wind of this and fired them. And it went up to the Supreme Court, and the Supreme Court sustained the state's action on the grounds that this was a neutral and generally applicable law. 3 years later, this leukemia case involving the city of Hialeah, uh, city leukemia Babalu was a or is a Santeria sect religion. The Santerians believe in animal sacrifice as part of their celebration and as part of their religion. They rented land in the city of Hialeah. City of Hialeah got wind of it in 1987 and immediately held a council meeting where people spoke out very vehemently and said some very ugly things. Members of the board said ugly things also. Why do we stop this? We can't let this go on. And they crafted a law that looked on its face to be neutral and generally applicable. And it went up to the Supreme Court 2 years after Smith with the idea that, well, we've complied with Smith, we drew the law proper, and it should be sustained. Well, the court in Leukemia looked beyond the mere wording of the statute and said, look at all the activity surrounding it. This is clearly not neutral. Even though you worded it neutrally, you were really targeting this church and these people and this religion, and they struck it down. That's really the horns of the dilemma here that the court must decide. Either you go with Smith and you support the city of Philadelphia and find it to be neutral, generally applicable law, or you go with Lukumi, and you find that outside of the law, there are facts and circumstances that targeted the Catholic Church here and tried to get them out of this process. So it's all about the neutral and generally applied law. And the Catholic Services asks that if you can't apply Smith, maybe it's time to take this 30-year-old case and change it and eliminate it and overrule it and come up with a more manageable law that allows for Catholic Services to perform its services in this new faith-based situation. So I think this case has dozens of amicus briefs submitted and is going to be a very high profile and get a lot of publicity before it's decided and when it's decided.
Anytime you have these free exercise cases, they always get a great deal of attention. And of course, with the probable shift in the court, it'll be very interesting to see the directionality of that.
Yes, very much so. Very much so. The this comes pretty quick on the heels of the bakery case, and the exercise of religion, and again, all of the faith-based groups and all of the LGBTQ groups are all piling in amicus briefs as a test to see that this is done the way they want it done.
Mm-hmm. Fascinating. Well, from that to something a little bit more mundane, I must say, but something again that applies to, or potentially applies to all of us every single day. Um, VanBuren was a police sergeant in a town in Georgia who asked a potential suspect that he was investigating to make him a loan of $15,000 to pay his son's medical bills, allegedly. The suspect turned him into the police for a shakedown scheme. And the FBI and the Georgia FBI set up a sting operation in which the suspect, Albo, was asked to give the sergeant a name, give VanBuren a name, and ask if VanBuren could look into whether this individual was a federal agent or not. And the test was, of course, to see if VanBuren would take any action on that, which he did. He accessed the Georgia Bureau of Investigation databases and made searches intended to research this individual, was arrested for it, and was charged with, among other things, a federal statute on computer fraud, 18 USC 1038-2, which essentially is designed to prevent people from accessing government computer systems or other computer systems for improper purposes. The question presented is actually a fairly narrow question, but it has broad implications. The question, of course, is a person with authority to access a certain computer system, do they violate that section if they use that access for another purpose, a different purpose than the one that was intended? So it's useful to take a look at the statute itself on this one. This is 1030 A2, and there's two highlighted provisions there, which really are the crux of this. Primarily B, because of course, what the sergeant did was to access information from a department or agency of the United States. But also information from any protected computer, extraordinarily broad provision there. So if you take that C back into 2 itself, whoever intentionally accesses a computer without authorization or exceeds authorized access and thereby obtains C, information from any protected computer. So both B and C are implicated in the case, and the question, of course, is whether or not this type of access is what was meant by the statute, by the legislature when it created the statute. The implications or the arguments have taken on an extremely broad stance. VanBuren arguing that because of the way the government interprets the statute, literally all of us could be violating that statute on any basis when we, for example, use a computer at work to check personal email or to make an appointment for a haircut or something like that, because it is exceeding authorized use to do so. And the computer would arguably be protected. The government, on the other hand, says, show us one case where the government has prosecuted someone under this federal statute for doing all of these things like checking sports scores and so on. It's a trivial possibility that the government would use the statute for that purpose. The statute also provides a civil right of action for violations, and the government also thinks that's trivial because the damages are limited to $5,000, and most of the cases where it would actually apply are not the sort of thing that VanBuren is concerned about. So notice it is a federal statute, a federal criminal statute that's being interpreted here. We don't get too awfully many of these kinds of cases, but that's why it's up at the Supreme Court for review after VanBuren lost below. Of course, if the court adopts an extremely broad interpretation of this statutory language, well, we'll all have to be a lot more careful, potentially subject to prosecutions if the government should choose to act that way. All right, well, let's go over and talk about these two Ford Motor Company cases, Dr. Cusick.
Okay, first of all, let me say that I used to work for Ford many years ago. I was a tort lawyer, and I worked for Ford Motor Company defending cases like this in products liability. And I can assure you they are very serious about their defenses, obviously going all the way to the Supreme Court, a subject that is near and dear to the heart of every civil procedure teacher and student, because you do spend the better portion of a few weeks, I teach civil procedure too, the better portion of a few weeks discussing jurisdiction of the person in civil litigation. And that's what these two cases are all about. One arises out of the Minnesota court system, and the other arrives to the Supreme Court from Montana. But they're very similar questions. They really address the question of whether the arise out of or relate to requirement of 14th Amendment's due process clause is met when none of the defendant's forum contacts caused the plaintiff's claims, such that the plaintiff's claims would be the same even if the defendant had no forum contacts. So what we're talking about here is the contacts that International Shoe developed and require as an interpretation of the 14th Amendment, and the contacts necessary to satisfy the 14th Amendment must arise out of or relate to this activity by the defendant. So let me give you the facts of each case, and you can see what we mean with Bandamar. Ford manufactured a Crown Victoria automobile in the 1990s, a 95 Crown Victoria automobile. They, let me see here. No, I'm sorry. Bandamar is a Ford Explorer, 1997, manufactured in Kentucky, sold to a dealer in Washington, sold to an Oregon resident, and then drives into Minnesota and sold in Minnesota. And it's a 14-year-old car. Ford hasn't seen it since it left its hands in 14 years before in Kentucky. Accident in Minnesota with an airbag that fails to deploy, allegedly, and the plaintiff is seriously injured. And Ford gets sued, having no contacts with this car or this event in the state of Minnesota. It moves to dismiss for lack of jurisdiction over the person, alleging some authority like Bristol Myers and Walden. We'll talk about those cases in a moment. But the essentially saying that they have no contacts and therefore under the 14th Amendment they cannot be held for trial in Minnesota. The Minnesota courts see this otherwise. They apply the Minnesota court Supreme Court applies its a certain level of its test and sees a causal connection between what Ford does outside the state having consequences within the state. So the effect is that the Minnesota test is a 5-factor test that really relies upon almost everything that Ford is doing outside. You know, it's marketing, it's selling other vehicles, it's arguably, according to the Minnesota court, taking advantage of the state of Minnesota, using its roads and its system and its commerce, putting this into the stream of commerce, and then the consequences are bad for a Minnesota restaurant, a resident, a Minnesota road, and Minnesota courts. So Ford should be held to pay for that and answer for the consequences of its own actions with this Crown Victoria vehicle. And the question before the court, of course, is there jurisdiction over Ford because of the activity it does outside the state, causing consequences within the state? And then we see the same question, or virtually the same question, in the Montana lawsuit, where that one involved a Ford Explorer. It's manufactured in Kentucky, sold in Washington, sold in Oregon, and makes its way into Montana, the same routine. The Crown Victoria, by the way, was made in Canada. I mixed them up a little bit. But either way, the Ford Explorer is 13 years old, and it's 13 years since Ford handled it. And the car goes into, is sold into Montana, and a Montana resident is injured while the car is arguably poorly designed or has a design defect. And the same question arises there because here the Montana court applies what it calls the stream of commerce theory plus. You put it into the stream of commerce plus now makes you answerable in the state of Montana for the consequences of this action. All right. No general jurisdiction that we speak of. They claim in both courts that this is a form of specific jurisdiction that you put in the stream of commerce years before and should have known, or it was reasonable to assume that you would expect it would have consequences in the state someday, sometime, and therefore it's no surprise and no burden to you to answer for it. Now, they have both cases emphasize, both states emphasize the burdens on their residents, on their systems, and the consequences to the people in the state. So Myers, the burden on the defendants, that these state courts cannot put an unfair burden on the defendants. And that's the argument that Ford has in its favor, is that we get dragged into this court, into this state, without any type of, or without any type of positive act by ourselves regarding this incident. And that it creates a tremendous burden on us that we shouldn't have to answer. So with Bristol Myers, the Bristol Myers decision, that was a case involving Plavriks, and several hundred plaintiffs in California sued, and many of them were non-California residents. And the Supreme Court took a look at it and said, these non-residents California residents have no Bristol Myers and Cal brought to California just because they have a whim or a desire to sue them in California. They have to go where they can find Bristol Myers, where Bristol Myers has actual contacts. So once again, the Ford argument is like the court keeps looking at this issue. Product manufacturer, Ford sees an opportunity here, I think, to get a resolution that will narrow the exposure to specific jurisdiction where they have actual contacts generating the accident or the incident. And I think that's their goal. And I think both cases are very good for that because they have these cars are very old, and the design defects go way back almost another generation. So how long can you hold them in, and how long do these contacts last? That takes care of the two of them then.
Yeah, that's fascinating. As a baby lawyer, I had a products liability case, not unlike that, Dr. Cusick. We had a lawnmower that had been sold something like almost 30 years before that allegedly caused a harm, and of course, it was complex to prove that that lawnmower was state of the art in 1960 or whenever the thing was sold, because this was some time ago. So fascinating case and great on the jurisdictional questions we all study in civil procedure. Well, we've got just two more quick cases for you. One is a big one, and that is challenges to the individual mandate of the Affordable Care Act, in which California and Texas are at each other's throats, along with a number of other states as plaintiffs, over this question of the constitutionality of that mandate, and more broadly, the constitutionality of the Affordable Care Act if the mandate itself is an unconstitutional provision. It's a little bit complicated. The Affordable Care Act itself includes a statutory provision saying that the individual mandate is at its core. And therefore, the argument is that if that is invalidated, then the entire statute is invalidated because Congress has expressed the intention that this is not severable from the rest of the act. There is severability jurisprudence that has developed over many years to determine whether or not a statute survives when one of its provisions is found to be unconstitutional. The Supreme Court, as you know, in 2012 found the individual mandate constitutional. Thereafter, Congress changed the penalty associated with the individual mandate to zero. The arguments in these cases are that in so doing, Congress essentially invalidated the individual mandate as a tax, which was the basis for it being upheld in the first place. In other words, the individual mandate was upheld in 2012 as a valid exercise of Congress's taxing power in an opinion written by the Chief Justice. Setting it to zero, the state of Texas argues, means that it is no longer a tax, and therefore it is an unconstitutional provision. So it's a complicated case with a number of different sub-issues related to it, but it boils down to the continued viability of the ACA, particularly as a result of what happened with respect to the individual mandate down the road. Here's a little bit of the argument that is set for November 11. The constitutional arguments, of course, about the best reading of that statute, including the severability claims. The California petitioning to support the ACA and the individual mandate argues that it is simply still a choice. You have a choice between paying a tax that is actually $0 or choosing to purchase individual health care. The fact that it's $0 changes nothing in terms of the constitutionality of that provision. Whereas Texas argues that in making it essential, Congress expressed the sense that it has to be a functional part of the statute. Otherwise, the statute itself is unconstitutional. Once again, this is probably the most contentious of the cases that we have in the term, or one of the most contentious of the cases that we have in the term. The other case that I have for you that was argued today, as a matter of fact, is a political case about the selection of judges in the state of Delaware, which has a constitutional provision that specifies that judges must be either Democrats or Republicans. Adams, the plaintiff in the original case, was neither, and therefore determined that he would not be eligible to be a judge, even though he had been with the Department of Justice and was probably otherwise qualified. So the question is the constitutionality of a state law that limits judgeships to members of two identified political parties. It becomes interesting law because, of course, we have some federal law about federal employment or government employment that says you cannot discriminate on the basis of political affiliation in government employment. And so the argument, of course, that Adams has is that political affiliation is unnecessary. It's inappropriate under those standards. There is an exception for purely political offices, not purely, but for offices that involve political matters. And so, of course, the governor of Delaware, Carney, has argued that this is a political position, and therefore it is permissible under the exception. Adams argues that judges are not political, or not supposed to be political, and they are not supposed to protect the interest of their party, but rather the interests of the law and its fair application. So it brings out a lot of the issues that we will end up discussing as a society in connection with the direction of the Supreme Court itself in this somewhat politicized environment of the day. I want to encourage everyone as we kind of conclude our main presentation to log in and listen to Supreme Court arguments live, something you've never been able to do before, but as a consequence of COVID, the Supreme Court is now live telecasting the arguments. This is the sort of advisement on it, and you'll see that there are arguments coming up the rest of this week and into next week that you may find interesting. Just take a look at the court's docket to find out which cases are being argued on which days. It's very, very interesting to listen to them, and now you can listen to them live. With that, we only have one question posted, and it's not a particularly pertinent to any of the cases that we talked about in our session tonight. So we will at this stage ask if there's any other questions. Send them in right away. Otherwise, while you're doing that, I will thank Dr. Cusick for his time and his hard work looking over the Supreme Court docket to get us ready for this session tonight. Any closing comments about what you see ahead, Dr. Cusick?
No, it's just going to be a very interesting week and interesting year on the Supreme Court.
It certainly is. It always is, but this one has an extra special flavor of a few little twists and turns. Not a lot of big cases on particularized individual rights, but a lot of cases with some important consequences and important long-term consequences as well. All right, well, there being no more questions, I think we will conclude it there. Thanks everyone for joining us. I hope you found it a useful look ahead to what you'll see in the newspapers, as they say, during the coming remainder of the term. Thanks for joining us again, and look forward to being more contact with you about St. Francis. If you find yourself interested in looking into the law school itself, take a look at our website. We're very proud of what we do here. Thank you very much. Thank you, Dr. Cusick, and good evening, everyone.
Good night, Greg.
Good night.